I'm Kevin O'Flaherty. I hope you enjoyed this Learn About Law video and podcast presented by O'Flaherty Law. If you need some help, please feel free to give us a call at 630-324-6666. That's 630-324-6666. We offer free consultations in many areas of law, and we have several locations for your convenience. Thank you so much for watching and listening.
Hi, this is Andrew with Learn About Law. Today, we're asking the question, can a creditor file a claim against a deceased person's joint tenancy assets or a claim against the survivor and joint tenant? We'll discuss creditors' access to joint tenancy assets of the deceased person and their surviving tenants, and we'll also discuss a few drawbacks and limitations to be aware of when considering joint tenancy with respect to creditors' claims. So first off, can a creditor go after joint tenancy assets? So joint tenancy with rights of survivorship is extremely common between spouses, and in nearly all cases, creditors have very little to no rights against property held in joint tenancy between the deceased person and the joint tenant. So upon death, the decedents, that's the deceased person, interests transfer directly to the surviving tenant, escaping probate and the legal reach of the creditors. This may make it sound like joint tenancy is a done deal with little to worry about, but however, it is not foolproof. And below, we're going to talk about a couple restrictions and limitations associated with joint tenancy assets. So first, let's talk about death of an individual and spouse involved in joint tenancy. So two people dying at the same time, right? While it is true that if a spouse dies, their interest in the property should avoid probate and pass directly to the spouse or joint tenant, but if a husband and a wife die in a car accident and the proper will and or trust was not constructed prior to death, then the property may pass through probate. While this scenario is less likely, it does still happen, and being aware of this serves to highlight the need to add a new joint tenant after the death of the spouse and or get proper estate planning. Secondly, more is not always merrier in joint tenancy. Be aware that any time another person is added to a joint tenancy, you are subjecting that property to the reach of creditors connecting to the new joint tenant. This may seem obvious, but due diligence is critical when it comes to forming a joint tenancy. Third, non-spousal joint tenancies can be treated differently and may be subject to subject the estate to additional costs in the form of unnecessary litigation. The general rule is that joint tenancy assets pass directly to the surviving tenant, but if it can be proved that the decedent actually intended for the joint asset to pass to their estate and not their surviving joint tenant, red flags will be raised, likely leading to needless litigation and costs. So not good. Fourth, do not assume that the law applicable to the joint real estate property and joint bank accounts are the same. Generally, rules surrounding joint bank accounts and what happens after death are going to be determined by the contract between the bank and the depositor. This means that if in the agreement between the bank and one of the account holders, again that's the depositor, or think of the joint asset holder, the account holder can unilaterally pledge the interests of all the other depositors, resulting in that decision holding weight past the original joint tenant account holder's death, muddying the waters during probate. So generally, joint tenancy is a safe and common way to avoid probate, protect real estate and other property upon the death of one of the joint tenants. It is, however, important to note that if any of the joint tenants owes a debt of any kind, credit card, liens on property, etc., their assets, while living, are still subject to claim by creditors in order to resolve the debt when alive. The specifics of a will and or trust will determine what kind of access the creditors have after death of one or all the joint tenants, hence the importance of having an ironclad trust in place. You can learn more about joint tenancy assets, property, and the probate process by checking out some of our other articles on Learn About Law. Thank you for tuning in.
Hi, Kevin O'Flaherty again from O'Flaherty Law. Hope you enjoyed our presentation of Learn About Law. If you need some help, please feel free to give us a call at 630-324-6666. That's 630-324-6666. We offer free consultations in many areas of law, and we have several geographic locations for your convenience. If you found this helpful, we'd love it if you'd subscribe to us on YouTube, SoundCloud, Apple Podcasts, or wherever you listen to your podcasts or watch your videos. Thank you so much for watching and listening.
Thanks so much for watching our video. If you have any questions, feel free to comment below. Click the subscribe button for new videos every week and download and review us on iTunes. Visit learn-about-law.com for other legal-related articles and videos. Visit our business podcast and video blog, seizeyourbusiness.com. Call us at 630-324-6666 for a free consultation.